It is my honor, my true pleasure to invite everyone, again, thank you for our patience in getting started, but to invite everyone to today's panel on state accountability and dealing with the legacy of the past after the historic 1998 British-Irish Peace Accord. Welcome to everyone all over the United States, not only here at the University of Massachusetts in Amherst, but in other states and in several other countries. My name is Leah Wing, and I am a faculty member in the Legal Studies program here at UMass, and I'm the director of the National Center for Technology and Dispute Resolution, and I'm honored to be a member of Healing Through Remembering organization in Belfast. I direct the Art of Conflict Transformation event series that is hosting this spring's events to celebrate and critically examine the Belfast Good Friday Agreement, which is now in its 25th year. The agreement between the British and Irish governments and the political parties in the north of Ireland, Northern Ireland, set out an architecture for shared governance and for new and reformed institutions based on equality and democratic dispensation. In this event series, we've held 3 events so far that have celebrated the extraordinary achievement of reaching this peace accord that made all of that possible. Yet despite the significant progress made, there remain outstanding challenges that the agreement did not effectively address. Atrocities and loss impacted all communities during the conflict, including at the hands of the state. Questions of accountability are central to debates about transforming societies during and after conflict, and particularly challenging can be addressing questions of state accountability. This panel is going to focus on the impact of not having addressed the legacy of the past in the agreement, but also the resilience and the perseverance of advocates for state accountability. I'm going to serve as the moderator for today's panel, and it's my pleasure to welcome our distinguished panelists, Gráinne Teggart, Padraig Muirigh, and John Teggart. Each will share from their insights on this topic, and we're going to look forward to your questions at the close of their contributions. But I welcome you to put your questions and your comments in the question and answer box at any time. So now let me briefly introduce each of our panelists, and then I will hand it over to Gráinne to begin us today. Gráinne Teggart is Northern Ireland Deputy Director for Amnesty International UK, where she leads its campaigns, strategic litigation, and political affairs across a range of human rights issues. Gráinne has a well-established track record of bringing about critical human rights change and is a respected human rights commenter, frequently appearing in local, national, and international media on key human rights issues. Gráinne is leading Amnesty International UK's campaign on achieving a human rights compliant way to deal with the legacy of the past and working closely with a number of victims. And she also recently led Amnesty's campaign to overturn a 160-year-old abortion ban in Northern Ireland, playing a key role in challenging the law through the courts and advocating for change in the UK Parliament. Outside of Amnesty, Gráinne is also the director of the Integrated Education Fund and Informing Choices NI. Our next speaker will be Padraig Muirigh. Paddy's a director of Muirigh Solicitors in Belfast. He's an experienced legal practitioner who specializes in inquest law, legacy inquiries, actions against police, human rights law, judicial review, criminal law, and strategic litigation. He's currently involved in high-profile campaigns relating to the Ballymurphy Massacre, the Spring Hill Massacre, and Kelly's Bar bombing. He successfully applied to the local Attorney General to have inquests reopened into a number of legacy cases, including the deaths of 10 people shot dead by the British Army in Ballymurphy in 1971. Paddy acted for a number of families in legacy inquests. On each occasion, the coroner found that the force used by the state agents in the circumstances of the death of their loved ones was unjustified. The successful findings include the following: Francis Roundtree killing, Henry Thornton findings, Bernard Watt findings, Joseph Parker findings, Marion Brown findings as well. He has also issued civil proceedings against the Ministry of Defence and the British government on behalf of hundreds of former internees in relation, to the legality of internment and their ill treatment. He's also actively involved in progressive development of law and the promotion of equality and social justice outside the courts. Paddy has been an advisor to members of the Assembly, Policing Board on issues relating to legacy investigations, the police, and public policy on justice. He has also used his expertise to provide assistance to negotiations related to the Colombian peace process held in Havana, Cuba. He supports the work of Inquest and is a member of the Inquest Lawyers Group and Haldane Society of Socialist Lawyers. And our final distinguished guest today is John Teggart. I will read the bio he wrote in his words. I represent Ballymurphy Massacre families. I was 11 years of age and just finished primary school, set to go to secondary school in September 1971, a month after when my father, Danny Teggart, was murdered on the 9th of August, 1971. I am one of 13 children. My mother and father were of mixed religion. I started campaigning for truth and justice in 1998 for my father and 10 other victims who were murdered over 3 days in August 1971 by British paratroopers, the same regiment who were responsible for the Bloody Sunday massacre 6 months later in Derry. The Ballymurphy campaign was successful in 2021 in overturning the British state lies that my father and 10 other neighbors were gunmen and a gunwoman. The presiding coroner stated, quote, all those killed in Ballymurphy were entirely innocent, posed no threat, and unjustified force was used by the military, unquote. Our work continues. So without further ado, I would like to hand things over to our panel. And Gráinne is going to start us off by giving us a sense of the relationship between dealing with the past and the agreement.
Hi everyone, I'm delighted to be here, and as the event is part of the 25th anniversary of the Good Friday Agreement series, I'll start my comments there. There have been a lot of reflections over the past number of days and weeks on this anniversary, and it's a time for us, I think, to rightly mark what the Good Friday Agreement achieved, including the foundation it provided for peace, rights and progress. But also I think it's important that we not be too self-congratulatory and critically reflect on how far we still have to go. Crucially thinking about those groups in society that have been left behind during this past quarter of a century and indeed longer. And I think one of the critical groups that typifies this point is victims of the conflict. The Good Friday Agreement focused on political and legal reform, including the release of political prisoners, decommissioning, reform of police and the criminal justice system, and the enhanced protection of human rights. It did not provide mechanisms for dealing with the past. The agreement, by focusing on the future, meant that it was also devoid of any detail or a roadmap to deal with victims of conflict-related violations. But crucially, what it did have when we consider state accountability and addressing those conflict-related violations was a vital and necessary express commitment for the European Convention on Human Rights to be put into our domestic law, providing for direct access to the courts and remedies for breaches of the Convention. And that commitment was given effect through both the Human Rights Act and the Northern Ireland Act. And that particular point on access to the courts and remedy for rights breaches are important points in relation to the Troubles Bill currently proposed by the UK government, which we'll come on to shortly. But in essence, what we have had is a piecemeal approach to dealing with the past, relying on different investigative aspects of the criminal justice system, including police investigations. So previously, the Historical Inquiries Team, now the Police Service of Northern Ireland's Legacy Investigation Branch, the Office of the Police Ombudsman, legacy inquests and civil actions. Police investigations in particular have had serious issues with regard to their capacity to independently investigate state actor cases. All of them have been too slow to deliver for victims, certainly slower than we would hope for, or that victims, I think, would rightly expect. And the patchwork of mechanisms, the systems of investigation on the whole, not fit purpose of comprehensively and systematically past human rights abuses, but there are circumstances and there are some of those which have delivered for victims. And without the implementation of what's called the Stormont House Agreement and the mechanisms that were agreed within that, the Stormont House Agreement was the most recent agreement between the British and Irish governments and with the support of local political parties to deal with the past. So I suppose to varying degrees, these measures have proved to be very vital tools for truth recovery and a measure of accountability for Troubles-related matters. So we'll come on to the Troubles Bill, but I will say from the outset that when we see the intent of that bill, it raises the very legitimate question of whether current mechanisms, including inquests, have been working a bit too well. And that's why the UK government are now moving to close down effectively all paths to justice for victims. So I'm just going to touch briefly on some of the mechanisms that we've either had or currently have until this bill takes effect. And then I'll move on to the Troubles Bill before handing over to Paddy, who will obviously speak from his experience with clients that have been sort of working their way through these various mechanisms over the years. So if we consider, for example, public inquiries into conflict-related events, probably the highest profile one being the Savile inquiry, which delivered the truth of Bloody Sunday and forced the hand of the then British Prime Minister to acknowledge and correct the public record of what was a mass state killing and utter those infamous words that it was unjustified and unjustifiable. You know, Amnesty and indeed many others, we have criticised the Inquiries Act as a framework for governing inquiries into controversial killings because it provides the government with powers to impose restrictions on the inquiry where necessary, as they deem to be in the public interest. And we've seen obviously how that has been exercised to ultimately amount to obstruction. And I think we've seen time and time again, even matters of national security, which I'm sure Paddy will mention, you know, where the UK government have used that effectively to block justice and prevent truth. Police-led investigations, which were first under the Historical Inquiries team and then the PSNI Legacy Investigation branch, there have been issues there with impartiality in relation to the investigation of state abuses, issues obviously around their independence, particularly around effectively the engagement of retired RUC officers throughout various stages, from collection of intelligence gathering to delivery of resolutions, etc., that it has tainted the whole process, and there has been very evident bias there. With the police ombudsman, there are notable gaps in powers there, which have been acknowledged by the office as well, particularly in relation to issues around compelling the supply of information, evidence and documents, which the police ombudsman would believe to be relevant to their investigations. On inquests, as John and our family know, and thanks to Paddy for his exceptional work, coronial inquests, which in sort of layman terms are best explained as an inquiry into the circumstances of deaths, have been delivering for victims, and the Ballymurphy inquest in particular, I think, has so well demonstrated how capable that mechanism is of delivering truth and vindicating victims' rights in that regard. I think there are currently, Paddy can correct me on this, but I think there's possibly 22 inquests into 32 deaths pending. And that obviously doesn't include those where there have been applications made to the Attorney General for Northern Ireland. There are also criminal trials, and I had the real privilege and honour of working recently with the family of Aidan McAnespy, who was killed by a British soldier on his way to a Gaelic football match in 1988. That criminal trial delivered the first conviction of a soldier in the 25 years since the Good Friday Agreement, and it demonstrates that accountability before the law is still possible. I want to emphasise the fact that that is the first conviction, because if you contrast that with the narrative that is being peddled by the UK government, that there is, to use their words, a witch hunt against former members of the British Armed Forces, which they're using as justification for the Troubles Bill, it's entirely inaccurate. Civil litigation on legacy issues obviously have also delivered, but again, it's also a route that the UK government seeks to close down with the Troubles Bill. that sort of takes us to the Stormont House Agreement. And that agreement, which was a bilateral agreement, as I mentioned, between the British and Irish governments, and had the support of local political parties and indeed sort of the wider community, with some adjustments, the mechanisms proposed actually offered a way forward to deal with the past and successfully discharge the UK's human rights obligations. It was the first time we had that degree of cross-community consensus on the way forward. There was a draft bill that was consulted on, and it's interesting to note that one of the key findings that sort of came from that consultation was the overwhelming view that there is no support in the north of Ireland, Northern Ireland, for an amnesty. We saw the UK government reaffirm their commitment to the Stormont House Agreement in January 2020 in what's called the New Decade New Approach Agreement, which followed a period where our devolved institutions had been collapsed. And it made a clear commitment that the UK government would legislate within 100 days. But one sacking of a UK Secretary of State and a mere 2 months later, the UK government unilaterally reneged on that agreement and subsequently produced a command paper which outlined what would be an amnesty for conflict-related violations. They then went on to claim that they had listened to the overwhelming objections to that command paper, and then published the Northern Ireland Troubles Legacy and Reconciliation Bill, as it's called, the reconciliation part of that name being particularly ironic. So having spent decades fighting for some measure of truth, justice and accountability, victims in the north of Ireland, Northern Ireland, are now faced with the very real prospect of justice being permanently removed via this bill. The UK government are, as I've mentioned, closing down all paths to justice for victims, and it is frankly a sickening and cruel betrayal of victims, sacrificing their rights to protect perpetrators of very serious crimes such as murder, torture, and indeed other crimes. The bill itself fails to comply with the UK's human rights obligations. It's a very concerning interference in the justice system. It undermines the rule of law, and it will set a very dangerous precedent internationally by signalling to other states as well that they too can legislate to let state forces in particular off with those crimes that I've mentioned. So what we have seen, given the very flagrant breach of human rights obligations, is overwhelming criticisms from the United Nations, including the High Commissioner on Human Rights, and the Special Rapporteurs through special procedures, the Council of Europe Commissioner on Human Rights, whose office I've worked with closely as well as the Committee of Ministers at the Council of Europe also, who have, alongside Amnesty and others, offered a very thorough critique of this bill and made very clear to the UK government that the only way forward should be to abandon this bill and to work in partnership with the Irish government and indeed the political parties and civic society, including victims, to find an agreed way forward. Of course, they could also just the bill and revert to the Stormont House Agreement, which, as I said, offered that way forward. But if I will just sort of end comment at this point by saying that there is a very concerning pattern at the moment, and I think it's particularly all the more stark as we mark the 25th anniversary of the Good Friday Agreement, but a very clear pattern around the erosion of rights, domestic protections, international agreements. It's very clearly evident across various bills, including obviously the Troubles Bill. So our message to the British government has been that instead of diminishing those protections, they should be taking the opportunity of the 25th anniversary to recommit to the Good Friday Agreement and the promise of human rights, which was at its core and underpins our post-conflict society, and enhanced rights through a Northern Ireland Bill of Rights and other measures. And of course, as I say, abandon this Troubles Bill, which has no support in Northern Ireland and very serious concerns raised internationally, including by the US Congress. So I will pause there and hand over to Paddy.
Hello, it's great to speak to everyone. I think I'm having difficulty in my video. I think, are you having the same difficulty? Yeah. I think I'll probably proceed, or do you want me to go out and come back? Oh, I'm back again. It's great to speak to everyone on this issue, on legacy issues. As Gráinne said, the Good Friday Agreement provided a roadmap for the future for all of those involved in the conflict and for our whole society. And thankfully, that's been a very durable roadmap, 25 years on. now. We're still have some difficulties and some bad days, but thankfully we still have a peace process ongoing. It provided a legislative framework for the institutions, political institutions, policing reform, and criminal justice reform as well. But as Gráinne quite rightly said, it was silent on how we would deal with the past. And interestingly, Bertie Ahern, who was the Irish Prime Minister, talked about this just in the last day or two at an event at Queen's. And he had spoke about raising it at the talks at the time, and there wasn't much support for it then. Perhaps it was too contentious, perhaps it was too difficult to habitate at that time, and the agreement may not have got over the line with it. I don't know what the reason is, but what has happened is that many families were left behind. And as a young lawyer at that particular time, myself and other lawyers had to work with the existing mechanisms and had to do that as creatively as possible because they were very limited. Gráinne referred to the Police Ombudsman's Office, which was newly established. It wasn't established to deal with historical cases. However, we realised that there was a clause within the law, within the guidance of the Police Ombudsman's Office, which allowed for historical or cases more than 1 year old if there were grave and exceptional circumstances. In our view, misconduct by police officers during the conflict, particularly in relation to collusion with paramilitaries, was very grave and exceptional. And the Ombudsman's Office opened many historical cases on the back of applications by us under that clause, and eventually opened up an historical directorate, as they called it, to investigate deaths in the past. So we've used the Police Ombudsman's Office to look at police collusion with paramilitaries during the course of the conflict and police misconduct issues. But that didn't deal with military killings. And we had to then look at other remedies. And we looked at civil litigation, which is effectively suing the Ministry of Defence. And that process of suing allowed us discovery of documents which assisted families in finding out what happened to their loved ones. But perhaps the most important mechanism was inquest, which is a judicial investigation of a contentious death. And I know that there isn't a similar mechanism in the United States, but essentially it had a facility for us to look at the deaths more closely. With the development and of the European Court of Human Rights jurisprudence in this jurisdiction, it meant that those inquests would be far-reaching. And there are a number of developments which occurred, which were very important. We had a right to access to disclosure of military documentation. We had a right to family participation in the inquest and legal aid, which was funding for families to take cases to the inquest. And perhaps most importantly, we had an opportunity to test the evidence through cross-examination in the public court. This was vitally important in cases such as Ballymurphy, whereby we received statements from various military witnesses, civilian witnesses, but those statements were only as good as the statement taker. And we had an opportunity in the court to excavate that truth, because the truth is often buried, and the inquest gave us those tools to excavate that truth. And very often, the best evidence was achieved on the stand through cross-examination of a military witness or a civilian witness. And perhaps it might be helpful if I give you an example of that. In Ballymurphy, I do recall we had a civilian witness who was ciphered as C3, who came from the Loyalist community, Loyalist Unionist community. And he gave a statement in relation to the death of a Father Mullen who was shot dead in Ballymurphy in 1971. This was the local parish priest who was assisting an injured man in a field when he was shot dead. This account described how the priest in his robes claimed defence and went to the injured man and retrieved a rifle beside the injured man and placed it up his robes. Now, that was a false statement. It was a false allegation, an attempt to besmirch the reputation of the priest and justify the actions of the British soldiers who killed that innocent priest. Because we were involved in an inquest, we had access to the post-mortem and autopsy photographs, and it was very clear that the priest was not wearing robes when he was killed. We had also access to other witness statements, which contradicted the statement of C3. And we were able to engage pathologists and engineers and ballistics experts to re-examine the scene. When we pulled all that evidence together, it was very easy for us during the inquest process to undermine the falsehoods which were said about Father Mullen. And in fact, in the findings of the inquest in May 2021, the coroner ruled that Father Mullen and all the others in Ballymurphy were entirely innocent. So the inquest process was very important as it gave us the tools to achieve the best evidence. And without those tools and the information recovery process, which the new bill seeks to establish, the statement of C3 would be information. It wouldn't be challenged. We wouldn't have the facility to undermine it. It would exist without any real contest. And that's the kind of process the British government want to replace rather than inquests. So the inquests have been very successful in coming. They must come to findings and they must give a determination on whether force used was justified by the state. And that's very, very important. So the legal tools which we have used were not designed to deal with the past. And we have had to use them as creatively as possible. And over the last 10, 15 years, those tools have become very sharp. They were very blunt tools at one time, but they've become very sharp tools. And I don't think it's any coincidence or accident that the British government have now sought to close those routes down by preventing any new inquest, halting existing inquest, and disallowing any further civil litigation against the Ministry of Defence or the PSNI, the police. So we have a kickback, if you like, a counterinsurgency by the British government in relation to the work that's been done by families, the great work in the last 10, 20 years, and local NGOs and legal representatives who've been able to use those imperfect mechanisms as best as possible to come to proper findings in the last number of years. So, I mean, 25 years on from the Good Friday Agreement, we actually face our worst threat to families in terms of legacy. And akin to, dictatorships around the world, and probably worse than some of the dictatorships around the world, the British government are trying to prevent families having legal remedies in the courts. And I think it's a very retrograde step. I also think it's very detrimental to peace and reconciliation, because what we have seen in Ballymurphy, which was a community which had a very hostile experience with the state and also the judicial system. John will probably speak about his mother's experience in the courts almost 40 years ago, when she was treated very poorly, and I'll let John explain a wee bit more about that later on. But families now in Ballymurphy trust the judicial system. They trust that inquests can work. And I think that's very important now for peace and reconciliation in the future. Because when I'm challenging young people in my community, and I live not far from Ballymurphy, my grandmother was from Ballymurphy. When I'm challenging young people now in terms of how we move forward, I have very credible and quantifiable arguments that I can make and say that this is working. If those are taken away, my fear is that young people will see that there are no alternatives, and it makes it very difficult for people in our communities to persuade them to stay away from violence and other methods when they don't seem to be getting their way. So I think the legacy issue working is very important, not only for families in the past, but it's very important for the future and for reconciliation. And this legacy bill must be opposed, and I think the United States can play a crucial role in that. So with that, I'll probably hand over to John, and I'm happy to take some questions later on that.
Thanks, Paddy. Just like to start, our campaign actually started in 1998, so it was 25th anniversary of the Ballymurphy Massacre campaign, and we actually got together by accident, where Paddy was saying about the NGOs. It was a local NGO who organised an event where victims were invited, and they were also invited to tell their experience of what happened to their loved ones. So they had met in what they call a local festival, Fela, and there's a Roman mic, and the likes of my older sister Alice took a mic and says, "My name's Alice Harper. My daddy Danny Teggart was murdered 9th of August 1971." But the mic went around the room and different people took hold of how they were affected by the conflict, and but by the time it went around, you start to see a pattern. There's a pattern in the room of my daddy just wasn't shot in the back, which we would have thought for all those years, and shot 4 times. There was other people in the field with him, and the same thing had happened to Ems. And then as it went on, we decided to meet. So what I had, a cut long story short, we had our first meeting. We got the families together, and there was some work already done by like Janet Donnelly from the Murphy family, who had got some coroner's papers, some inquest papers, and we'll give the details of which we hadn't got for many, many years. So we started a plan for them. That was the start of the campaign. And then we continued the next number of months and the next year or so of starting an investigation. So what you had at the time, the police of the day, the RUC, did not investigate. They did not call the house. They did not tell people that their loved ones had been murdered or they'd be in the morgue. They had to go and find them. And the only participation by the RUC, the police at the time, was to take photos in the morgue of our loved ones. And that was for the courts. So like I say, we started getting this information, post-mortem accounts, and like up until then, I thought my family thought, well, he was shot in the back 4 times, and then in the end he was shot 14 times with 25 wounds all over his body. So that's the kind of information that started coming through, investigated by the families over the first couple of years. And basically, we were doing the police's job. We were rapping doors, and yards away from where our loved ones were murdered, and we were rapping doors and asking people that lived there at the time, if they did live there, to see what had happened. And from no civilian eyewitnesses at the start, we ended up over 200 eyewitnesses, which was brought a lower number to bring to our recent inquest. So that's what the families had to do. They had to investigate themselves. They had to take on the campaign. They had to do the work that authorities didn't do. And as we went on through and gained confidence and of what we should do next, we started lobbying and campaigning. And like I remember the first time we went to Muirigh. It was absolutely freezing. It was -18 October 2010. Leah would remember it. And we had arrived there, but we got an enormous warm welcome from the Irish American friends. And we had many meetings, which was organised over the 3 or 4 days that we were there, including a visit to Washington, lobbying with senators and congressmen in Washington. And from on the back of that there, we were successful in a congressional hearing in front of Congressman Smith. But part of the campaign was to raise awareness and gather support. So we done that. We went to European Court. We went all over the Great Britain, and all over the island of Ireland, gathering support. Not just political support, but people on the ground who were willing to help people. And then we had one of the biggest organizations in the world is the Catholic Church. It came a lot later, but the Catholic Church joined our campaign, which gives us a big boost, because it was actually one of their family members, for our mum, who was murdered. There was 11 people in total were murdered, and it was over 3 days. And the wounds would suggest that they were either shot in the back, shot lying down, or shot even lying down with their backs to people. So similar to what happened on Bloody Sunday. You have to remember that the ones who murdered our loved ones were the same paratroopers who were on the ground on Bloody Sunday, and the same paratroopers who killed Robert Johnson and Robert McKinney on the Shankill Road in September 1972. That was after Bloody Sunday. So you had this very brutal regiment who were put on the ground to actually police, or because the RUC wouldn't come into the areas like ourselves. But what had happened, and history will say that the army came in to help and support the Catholic community, the It says it was two factions. But what happened after that there, they didn't protect us. They turned their guns on my community. And I'll come to how we found that out. The mindset of Army generals and the parachute regiment of how our loved ones were murdered. But like I say, we campaigned, went all over the world, garnering support, and including a congressional hearing in 2011. And you have to remember, 2010, 2011, we hadn't got many options. There wasn't mechanisms put in place for people, victims like ourselves. So we had met Paddy. There was new the new government was set up. The First Minister and Deputy First Minister, and they appointed an Attorney General. That was the first Attorney General in the north of Ireland for almost 30 years, and that left the path up for after advice from Paddy. That left the path open for going for open an inquest, reopen the inquest, because all and the difference from the court then and now is in 1972 at the inquest, my mother was there and she had told us what had happened. You had the perpetrators, the paratroopers, laughing and joking about in the courts. They weren't called to give evidence. It may have been the odd one, which would have been one of an officer. And what had happened is the army brought an envelope over to the judge with all the names, which is called Safeguard soldiers. That's what had happened at the time. Now, for that this was their investigation. You actually had the Royal Military Police investigate their colleagues within the army, and what we had found later on in the inquest that these were crafted statements. Most of these soldiers weren't interviewed. Most of these soldiers weren't taking statements and didn't know about the original inquest because they weren't called in. So even the civil, and what happened in the civil, Paddy was hinting on, was my mother went for a civil. I just explained the way we were treated in the inquest. So the civil, which my mother tried to a civil case, but the MOD, the soldiers, and because my daddy wasn't working weeks beforehand, the judge had decided to say to my mother that, Mrs. Teggart, at the time your husband wasn't working, and now you're actually getting widow's pension. Financially, you're better off now when you've one less mouth to feed. So that's a statement from the judge. So people in my community had no faith in the courts, had no faith in the police. The soldiers had made my community an enemy, and we were classed as like a terrorist community. But that's the mindset of the army at the time, and their generals. This is the way they were briefed. You know, an example of that, they could have went to a bar half a mile from where Ballymurphy is and sat and had a drink below local bar multis. But the likes of what happened in Ballymurphy, there was 3 bar multis from the loyalist community, armed, and they're told to go away. Paratroopers took their seats on my community in Muirigh and Ballymurphy, and that's the difference. That's the difference between out there and their seats were on unarmed people. So, like I say, we were granted to reopen a new inquest in 2011, and that was a fight. That was a fight along the way. But what we had was with the advice from Paddy about the taking the inquest. One of the questions we had asked was, well, would we get disclosure? We're told yes. We get compellability of the soldiers to come and give evidence, and another yes. So we decided that's the road we'll take. But that was a long slog in 2011. You have to remember, 2011 were granted an inquest. There's preliminaries were in the court at the time. I got to the stage where the barristers for the MOD, Ministry of Defence, were told to bring certain progress to in front of a judge. And yet you have to remember, like, this is about 2 or 3 months at a time, where they're given a certain length of time to have certain evidence, files, whatever it was. And they were coming in 3 months later and saying, no, we haven't got. And then 3 months later again, they were given another deadline, and they come up, and it got to the stage where we're just shrugging our shoulders. No, okay. And that's what's always happening in the courts. But for things like that, it's different. I was 11 years of age when this happened. I'm one of 57 children who lost a parent within the Ballymurphy inquest over Ballymurphy Massacre over 3 days. So from 11 years of age till over 40, 50, as the campaign went on, you get to know things the way things should be. Now, we had no faith at all in the coroner's court and any legal system, because the police were brutalised my community, the army brutalised my community, and the courts didn't hold these people to account when they were brought in front of them. So that they're said and done. You had the Good Friday Agreement. You'd independent people growing into the legal system, where you started to get some kind of faith, or the likes of getting the inquest. Maybe we should go down this road. We'll see what happens. At least we'll get the files. At least we'll get disclosure. There'll be extra information for us. We'll go down that line. Antics of not just what the bar were doing, but also the judges. The MOD, and then at that time you started having social media, you started having smartphones. And whereas if you're not happy with what had happened outside, and we'll go out and speak to the media, but if the media didn't turn up, we used a smartphone and we used our own media. So you're actually telling people outside and around the world, where you have YouTube or whatever it is, Facebook and Twitter and all these different things, you were letting people around the world know exactly what's happening in the courts in Belfast. And is things changed? And that's the kind of questions we were asking. Are things changed? Are we going to have faith in the legal system? And the answer was yes, because there was changes. We got the right judge. She come from family background in the courts, and as it progressed, we got the right result. But you have to remember that, like Paddy says, going into court there was a big step for us. The first week where you told what I would call a compact statement, hard it affected the family and things like that there. So each individual family done that there. RFN, the way sitting through it and listening to people, part of their family was affected. It was really hard. And then you have the MOD, where they were actually cross-examining our eyewitnesses. These are supposed to be witnesses, but they're really hard on them. And then you see the difference from the military, when the military came in. They started coming on with their medals and things like that there. But then once the started in questioning, I would say we had some of the best barristers in the world employed by Paddy to what he called represent us. And it was different from them. They weren't used to this. No, you have generals who thought they could just say it and they will take the word of it. But after cross-examination, the way Paddy was explaining, like it was an example of that there. We had the the colonel and chief of the second battalion of parachute reds. We had him in the deck, and Paddy will call it a witness back. I call it that. But we had him in the deck, and he was asking questions, and they was saying like about people, the way he had spoke to his regiment, his soldiers, briefing them the way it was, and then he started to telling us. So the barrister started going on about Father Mullen got about hanky shift, just like Bloody Sunday. You remember the white hanky, well, there was no cameras in Ballymurphy, so the iconic figure was in Ballymurphy 6 months earlier. So when I started saying about him, this colonel who was over all of the whole regiment and troop power had says that because he was from that community, he was our associate with the IRA or in the IRA. Now we're talking about a priest here. So and then went on about, well, what about the young lad who went out, Frank Quinn, who went out to help Farmel? Well, if he's in the field, was there associated with the IRA or it was in the IRA? So you have that from this guy who was over all these 85 soldiers, at least, that was in Ballymurphy. So that's his mindset. So that feeds down his leadership. And that's why our loved ones are murdered, because we were told by the colonel, the soldiers were told by the colonels that we were the terrorist community. Everybody in Ballymurphy was there in the IRA, supported the IRA, associated with the IRA. And that's what happened in Ballymurphy.
John, thank you. It's very powerful, compelling, and tragic story of what happened to your family, your community, and your friends and their families. Thank you for sharing that, as well as your analysis of a long journey, a 50-year journey of slowly moving towards taking action to demand accountability and coming together with the Ballymurphy campaign and successfully achieving the inquest. It's a very moving story, and I know there's so much more to it. I was thinking about the movies made, the marches that you've held, the play that was created and to share the story. So much that we could spend time on as well. All the creative ways, not only the use of the courts to get the word out, as you said, through social media. I wanted to ask you one more question, and then maybe we could shift and just invite if Gráinne and Paddy want to add some more before we move to questions. But I wanted to ask you, John, you talked about so much of support from around the island of Ireland, in the rest of the UK, as well as in the US. But I wanted to specifically, if we could return back to the north and ask you to say just a little something about the work cross-community with other communities who, from loyalist or unionist backgrounds, both politicians and individuals who support the campaign or were working with you around state accountability. So if you could just say something about your experience with that.
Well, we've always worked with people across community events, cross community organisation and campaign groups. Even the likes of the anniversary of Shangle Bomb, we were invited to go across, myself and Breach Foyle, daughter of Joan Calney. We walked from the falls over till the anniversary at the church, and it was very, very emotional day, not just for the families of the Shangle bombing families, but for ourselves as well, to be invited, and we're very humble with that invite as well. But when you talk about the exhibitions, and we have used the arts for that as well, and that was part of cross community work we would have done. Even our first time trying to get into Stormont was done with an art exhibition, a photo exhibition done by Jonathan Porter, a local photographer. So that was, we actually started going through the arts to open doors, really. So we held this exhibition in Stormont, and we had all the political parties in the north who joined us. And someone stepped on to the campaign, the likes of Trevor Lunn and people like that there. Although we had many political groups who support us at any time. The families enjoyed that from cross community political figures as well. So even now, where we have this bill, myself and other victims groups have joined forces with the likes of the Yoma Bond families, the Gráinne McCord, who's heading the group, Truth and Justice Movement, and different people from affected by state violence within the Loyalist community, the Catholic community. It's a wide range of victims who we have joined force with. And one of the first things we had done, and that was never done before, we had every political party in the whole of Ireland in one room in the City Hall, and they were all supporting the families. They took a pledge to support the families on that day, to oppose the bill of shame, as we would call it, to this bill that the Tory government are taking in hand and running solo with it, because of a large majority, as they're in government, a very large majority. But the bill itself, the bill of shame, it is also opposed by all other political parties in both the House of Commons and the House of Lords. But this is what this group was formed. When I say that the cross community group for Truth and Justice Movement, it was formed to totally oppose it, and that's the kind of work we do cross community, and we help other campaigns. We were successful with our inquest. But Paddy will tell you also that as we're going forward there, and with a large campaign and an awful lot of support from way and afar, is that we had the mindset that anything that we get as a large campaign, a high profile campaign, the inquest was the biggest inquest in the north ever, and with that there, we want to set a standard. So if we get through anything, we get all the other people, whether it be individuals or campaign groups, would be entitled to the same thing. And we're very successful in that for getting the inquest and going through till the civil, on the back of the findings of the inquest, when all our loved ones were declared entirely innocent by Justice Keegan. So believe it or not, this bill was started on the day that our findings came out. It was in the Queen's speech, and it was dated for the same day. Now, we would have knew months and months ahead of that we were going in there for our findings, and so would the governments. And it came into my head at the time where there's a door closed after the Salve inquiry, although people would say that the Prime Minister at the time had no unjustified force or justifiable the murders in Bloody Sunday. But he also says that there'll be no more open-ended inquiries, and there hasn't been an inquiry since. An example of that was the Finnegan family, and then what the head says after our inquest, the head says that because we were successful conclude the inquest, because we were successful conclude with the civil, because we corrected history and shone the light on the state that that they murdered all our loved ones. This bill of shame means that the legal inquest, which everybody should be entitled to, no, the legal civil cases, which is everybody's entitled to, which we're successful in, And then they were talking about the prosecutions where they're giving an amnesty across the board. So we're successful, but on the back of that, because we're successful, I see that they don't want this any inquest coming forward there, and that's what the bill of shame is getting brought out. Is to actually close the doors of other individuals and other individual campaign.
Thanks, John. So I want to invite the audience now. If you have some thoughts, feel free to share comments, not only questions, but please feel free. We have several already in there. But before we turn to them, while the audience is mulling over what they want to ask or say, let me just give the mic again to Gráinne and then to Patty. Is there more that you want to add that you've been thinking about, especially as we look forward to the next steps regarding the fight against the Northern Ireland Troubles Legacy Bill, or what you anticipate happening?
I think, what John has just said in describing the process and what the inquest process delivered, obviously for the families, I think, just as it underlines just how cruel it is of the UK government, for a mechanism that is working to be swooping in with the Troubles Bill and effectively then closing that off for other families. I think, the Troubles Bill can be best described as a de facto amnesty. It's about ultimately it's about putting perpetrators of very serious crimes above the law and beyond accountability, and that's just the essence of what this bill is about. It's about delivering immunity from prosecution to state and non-state actors, and I think, for victims who have been fighting for a very long time, understandably, the only thing that this bill has achieved is actually uniting the entire community against it, and obviously in that fight. And when we consider then where things currently are with the UK government and their unilateral action, on this bill, the fact that they are not meaningfully engaging with the Irish government as co-guarantor of the Good Friday Agreement, because this bill also violates the Good Friday Agreement, the logical next step for us, and there has felt, I think, since we've seen the bill the day that it was published, there has felt like a degree of inevitable legal challenge at the end of this process because of the comfortable majority that the Conservative Party have in the UK Parliament that John had mentioned. So what I'm working on at the minute, and something that I'm pressing for very strongly, is what's referred to as an interstate case, and it's effectively the Irish government taking the UK government to the European Court of Human Rights. And I had met with the Irish Taoiseach, the Irish Foreign Affairs Minister, just within the past 2 weeks, sort of further on this, calling on them to put a public marker down to signal to the UK government that if they do this by way of pushing this bill through to law, that it will be met with that challenge, because I don't think it's right that the burden of legal challenge falls solely to victims, because victims have already been fighting for decades. And for the years it will take to go through domestic courts, to exhaust those domestic remedies and go on to the European Court if necessary, frankly, there are many victims who don't have the years left that it will take to go through that process. So it is critical that the Irish government play their role in this, and part of that role has to be that interstate case. So 25 years after the Good Friday Agreement, that's, I suppose, a bit of a healthy dose of reality of where we are. We are still feeling victims. And we're in a situation where we're calling on the co-guarantor of the Good Friday Agreement to challenge the breaches of the European Convention on Human Rights through this bill.
Thank you, Gráinne. It actually reminds me of the phrase about double injustice, the first injustice, and then the lack of accountability, the lack of truth being told or anyone being held accountable regarding that. Being another injustice. And we have this spread over, for the particular families in Ballymurphy, over 50 years. And there are, of course, many before and many, many after, when you have over 3,600 people murdered and over 40,000 injured, bereaved as well. So thank you for that. Patty, what would you like to share at this?
Yeah, just to add to what Gráinne said there, I suppose it's a dominant statement of the bill that all of the political parties in the North agree on something. And any political observers in your audience will know that that's a very exceptional, a very rare thing, that we all agree on something. It's quite an achievement by the British government. That's how bad the bill is. In terms of redress, I mean, families invariably this will end up in court, whether interstate case or a case taken within the domestic courts, and what ultimately might lead to the Supreme Court. Part of me feels that that's what the British government want as well, because there's a wider issue of the erosion of rights that's beyond legacy and the project of this British government. And they've also had showdowns with the Supreme Court previously on Brexit, at least that occasion, maybe on another occasion. And they've been pitting themselves against the judiciary and the right-wing media as well in some of their public statements. There's a wider attack not only on rights, but on the judiciary and the independence judiciary as well. So part of me feels that on the one hand, it's very clear that families will take a legal action. I think this government is very conscious of that and would like a showdown with the Supreme Court, and pitting the judiciary is interfering with the executive powers. And you see this as a trend in right-wing authoritarian regimes around the world at the minute, and unfortunately, in the United States and Europe and other parts of the Western world, you're seeing this trend as well. So I feel that that's going to be a battle. It invariably will lead to years of delay, and even if successful, either interstate or through the courts here domestically, the Supreme Court, many people will pass away who are waiting on inquests, who are waiting on civil actions, who are waiting on proper investigations and a proper mechanism. So it doesn't bode well. I think it's going to be a difficult process for us all if this bill goes through. Now, there's a small possibility of some amendments to this. We're very far advanced, and I think the United States administration has a key role to play at present. They listen to very few people, the British government, but they do seem to have, they seem to be concerned about how the US might feel about all of this. And if this bill was supposed to come into legislation in May, and it has been delayed by a number of months, and I'm hoping that that's because of some pressure as well, and that we may see some amendments to this. But I'm not overly confident of that. But we have to see. Unfortunately, we can't take a legal action until we see the legislation pass through the legislative process, and at the other side of that, when we see the final product, consider a legal action, which will invariably go through the courts and take a long time. So we have a difficult road ahead.
If I may just add just to something that Paddy has said there, because I think he's hit on an important point, which is around the UK government and various bits of legislation which have the very deliberate intent of conflict with the ECHR and by extension the European Court of Human Rights also, and it's not limited to legacy. We're seeing some of the more extreme sort of wings of the Conservative Party calling for withdrawal from the ECHR. And when we consider that that is a core component of the Good Friday Agreement, there are a particular set of difficulties and concerns that presents to the north of Ireland, Northern Ireland. And if we just think for a moment about the most recent, country to withdraw from the ECHR was Russia. So, this is obviously the territory that the current UK government are taking us into. But I think and also absolutely agree with the point around what we're seeing is a very carefully crafted narrative and demonisation of rights advocates, and what the UK government are trying to sort of criticise as lefty human rights, lawyers, which basically translates as those who are about vindicating rights and about holding the state accountable. But that is what they are trying to systematically close down and limit, any prospects for accountability on this and a whole other range of issues. So we are in many respects, certainly I feel through my work, in quite uncharted territory. It's quite difficult at the minute from a political advocacy point of view to engage with a government that is so intent and committed to this process of, removing and reducing rights. So we've also seen, if I could just quickly add, the Labour Party, which is the main opposition party in the UK. The party leader there, Keir Starmer, has said that he will repeal this legislation if it becomes law. But of course, and that's welcome, of course. But the problem there being that as soon as this bill becomes law, its provisions take effect. And even if it's repealed, it's then, we need an express commitment to what will be replacing it. And hopefully then that brings us back to the Stormont House Agreement, which will require some adjustments. But the aim has to be for this bill not to become law, and there has been some sort of pauses to this legislative process, but the US administration does have a key role to play here. We've seen and we've worked on coordinating some of the congressional interventions that we've seen to date. What we don't have yet is something public from the administration, and I've been meeting with the US State Department and indeed others, on this particular point, because the UK government do listen to what the US administration have to say on this, and in the same way that they were very clear and unequivocal around the protocol bill, for example, and the consequences that there would be there, if that bill went through. The effect of that warning from the US was for the UK government to re-engage and cooperate in a process that then ultimately resulted in the Windsor framework. So we could and should see something, I think, publicly from the US administration on this also. As I understand, they have been raising it privately, and we and others are continuing to engage. But I do think a public marker is significant, if even to give UK parliamentarians something to galvanise around in opposing the bill.
Again, I hear in both what Gráinne and Paddy are saying about the impact of multiple voices from both around the UK, across the partition divide, from Dublin and from the government there, as well as from the US, that there's possibility to make a real impact, as historically was the case in helping support the building of an agreement, the first agreement, the peace agreement. So if we could turn to some of the questions, we have one from Claire Hackett that says, "Thank you all for such compelling presentations. John talked about the historical record. Can I ask all of you how important is truth recovery and justice for understanding what the conflict was about and how it was waged?" So does someone want to pick that up?
I mean, I can answer that sort of quite succinctly, in the sense of it's critical. It's one sort of key component, or key, I suppose. So it's critical to what we obviously need to see going forward. Truth recovery is not going to be something that comes through this current legacy troubles bill, despite what the UK government are claiming. The intent is very clear to actually close it down. So if you don't have meaningful truth, what you have then are inaccurate narratives as well that are able to be peddled. And we need to, I think, through dealing with the past, arrive at a truth and a degree of consensus as much as can be achieved around, I suppose, an accurate narrative around what actually took place during the conflict here. Because what we see, and again through the lens currently of this bill, is an inaccurate narrative that is being peddled, that is being presented as the truth of what took place obviously during the conflict here, and we know that it's anything but. So it's essential, but it will only come through mechanisms that are capable of delivering that. And again, that's where we were very close with Stormont House Agreement, and if we could obviously go back to that place, it would deliver.
Perhaps if I could come in there just on the issue of truth. I mean, the people of Ballymurphy knew in 1971 what happened. So truth didn't arrive for them in 2011. What arrived in 2021 was legal vindication of that truth. So I think it's not enough that communities know what happened. I think it's very important, and I would say this as a lawyer, of course, that there are proper legal mechanisms and due process for these issues to be examined, and there's a search and inquiry into that. And truth is only achieved through that search and inquiry, or proper truth, or official version of that. And there were so many wrongful legal verdicts during the course of the conflict. I think it's imperative for future reconciliation and confidence in the justice system that they are overturned. And Ballymurphy is a perfect example of that. The courts abhor insinuations. They don't tolerate falsehoods. It's an evidence-based process, and that is critical, that it's evidence-based, because in social media or in the right-wing media has peddled these untruths over the years, and they still do it in terms of witch hunts against soldiers, when the truth is very, very different. And it's only in a courtroom, and we've seen it in the inquest they did in the last number of years. It's only in that sort of forum that we can desegregate the falsehoods from the solid evidence, and proper findings and proper narratives can be arrived at. So you need a search and inquiry, whatever form that takes, whether inquest or, as the Stormont House Agreement proposed to set up, was an historical investigations unit, which would be an independent body. We need to arrive at the truth. The communities know what the truth is, but the issue, and the important issue, is for reconciliation, the future of our communities. We need legal vindication of that, in my opinion.
Yeah, just like Paddy said, for victims and victims' families like ourselves, it's very important to bring the truth forward. We've always known the truth. We investigated it ourselves, brought it all forward, and legalized all the evidence, and brought that forward. And that needed to be done to change and correct the narrative that was set up by the soldiers. And you have to remember the courts at the time, in 1972, the word of a soldier or the word of a police officer would put you in jail. There wasn't question, and the third word was garnered as correct. So not only that, there for as transgenerational as well, because what you have is I have 11 grandkids, and if I hadn't been part of the campaign, my family hadn't been part of the campaign. If you go back in history, that my father would have been a gunman. These are the 11 victims in Ballymurphy, and others would have been branded gunmen unless we had a successful case to overturn and correct the original narrative. But that there needs to be accountability for that also. You know, if what happened in Ballymurphy, 11 people entirely innocent, as declared by the coroner, then there's a crime committed. That crime was murder. Although when we went through a legal system, Paddy has already explained that the inquest is only fact finding. The fact finding where all the evidence got together and to find out how our loved ones died. It was successful. But then, if there's a crime committed, our next step would be prosecutions, and this is what they want to close down the doors. Now, we're talking about 50 years. It's actually 52 years this year from my daddy was murdered, and the police haven't come to our door and saying, "Oh, see what all that new evidence. We start investigation." No, we had to go to the Emmons and prompt the Emmons for an investigation. And Paddy would go into detail of their responsibilities. Is that right, Paddy?
Yes, no, the families met with the police before Christmas. I mean, a file was forwarded from the coroner to the police, and that would be a separate investigation, which we understand is currently under review. Although we haven't spoke to the police in a number of months. We did speak to them just before Christmas. I had been liaising with them just after Christmas, so that process we understand is ongoing. But perhaps at a snail's pace, we haven't very much confidence that that'll work its way anytime quickly. And the concern is, in any event, even so, the bill would decapitate any possibility of that investigation going forward.
So there are two questions, Patty, maybe if I could keep the mic with you for a moment and then others can join in. Two questions maybe you could consider answering that follow on from this discussion. One is, are there punishments for false statements that are made by witnesses to these crimes? I think that person might be referring to C3 speaking during the inquest and then being cross-examined as giving falsehoods. And the other one is individual accountability just as important as organizational and state accountability? And the second one, obviously, anyone who wants to join in, but Patty, can we begin with you?
Yeah, in terms of punishment or sanction for false statements, I mean, a witness who either refuses or provides false evidence to court can be charged with contempt of court. So absolutely there is. The coroner or judicial figures don't always pursue that. Perhaps because they might argue that the person's memory is poor, that their interpretation of events are different from A and B. It was very clear to me what the intention was, and in that particular circumstances, it wasn't taken any further. Although the families and obviously the legal representatives are very clear that that was a clear attempt to besmirch the reputation of Father Mullen and to justify the use of force on the priest. But there are sanctions, but they're very rarely actioned, it would be fair to say. On the second point, individual accountability is absolutely. I think Gráinne gave the very stark figures of, the recent prosecution and the only prosecution for state violence, and given the number of cases of state killings over the years, that's quite concerning and disturbing figures in terms of individual accountability, but also there hasn't been any, and there has been, the bill talks about an amnesty, but in fact there has been a de facto amnesty for 40, 50 years, where through the prosecution, and John mentioned the old Attorney General had a particular view, and he put this in writing, that soldiers shouldn't be brought before the courts. The prosecution weren't pursuing these or prosecuting these cases. The RUC, who are the former police, were not investigating these matters either. So there's a whole system, justice system, or criminal justice system, was opposed to state accountability, or certainly weren't playing their part to hold the state to account. So individually and collectively, the state was not held to account during the course of this conflict. And this bill, at least when we have a recent example of that happening, again, like the inquest, they then want to close it down. I think it's no coincidence that that's happening in that time, because what you're getting from the successful inquest and from the successful Savile inquiry, it leads to the next point that you all talked about. The inevitable route then is through prosecution process. And their concern is, if all these inquests take their course, that there'll be more prosecutions against soldiers, and they want to stop them at an very early stage.
It's understandable from victims and families' point of view, that if there's an individual that's highlighted evidence to support that he had murdered a certain family member and the Ballymurphy massacre, that needs to be addressed. It's important for the families if the soldier or soldiers, as we're talking about, who have put themselves forward as certain shooters, albeit the different narrative of what happened on the day, but that narrative changed in the inquest, and so these soldiers who and the for the coroner to say that some of the stuff that they were saying was untrue, and she wouldn't use their statements as evidence in a way. It's obvious that the families are going to pursue the prosecutions, but this here bill, as we know what it's for, if anybody goes on till the British Tory government, Conservative government website, the guy who crafted this here for the government, Brandon Lewis, he has stated in his words, no more will our soldiers, our veterans serving the country, be brought to be questioned. Now, he's actually saying they don't want even the soldiers questioned. That's what this bill is for. So families like ourselves, my grandfather was part of the British Army many years ago, and he would turn in the grave of the antics of like the parachute regiment killing and civilians, and it has to be said, at the moment, this is part of Great Britain, and the north part of the Great Britain, and on the soil of Great Britain, to have the soldiers who are supposed to attack the shooting local civilians. Obviously, they would want, ex-veterans would want those bad apples, although there's a big orchard of them, they would want them bad apples brought to account for bringing shame on their regiments, obviously.
Yeah, we just just add to the point that John had mentioned there around, them not wanting them questioned, and the intent, with this bill. That's obviously, it's absolutely right. Although depending on the audience the UK government is speaking to, they obviously slightly tailor that message. But I think it's reflected in what is the core of this Troubles Bill, which is a new body. It's called the ICRIR. It's about reconciliation and information recovery. But the threshold with that particular body for information is so low that you could effectively, to give an example, have a soldier turn up without the knowledge of the victim's family, for example, take part in this process, give information that is already in the public domain, and qualify for immunity from prosecution. And this is a body that the Secretary of State would retain control over its resources, its caseload, could decide its appointments, could decide to obviously end its work at any time, is time limited not to obviously to to 5 years, etc. So it is a very blatant attempt to basically swoop in and close down what is currently working and also permanently deny truth and justice to victims here. And as we've all sort of made the point that truth, justice and accountability is critical to building a reconciled society. You know, we're 25 years on from the Good Friday Agreement and there is still very clear and evident division in society here. So we're not going to achieve that by the UK government pushing a bill like this through to become law. And just, you know, one other point, it's just something that, you know, keeps recurring as we're having this conversation, which is, you know, time and time again, we have seen the state say that the use of force at times was justified. And when you have inquests like Ballymurphy and you have other cases like the criminal trial, the Aidan McAnespy case, and it's correcting that public record. And it's shown that obviously that wasn't the case. So it is no coincidence that this is now what we're fighting against in terms of the proposals with this bill. So yeah, just to add that.
Gráinne, if you don't mind keeping the mic, I'll invite you to take a weigh in on the last question we have time to take. It's from an anonymous attendee, and it says, considering the UK has kind of avoided accountability in many different examples of colonial atrocities, do you think if they are able to be held accountable for what they did during this conflict, that could lead to further instances of being held accountable for other things they have done?
I mean, the short answer is yes. I mean, it goes back to the point that I mentioned just in my opening remarks around the international precedent that this bill will set. I think there's a lot of, if we consider conflicts around the world sort of currently, and obviously previous conflicts also, there will be a lot of states looking on, sort of rubbing their hands in glee that what the UK government are trying to do here, and if they succeed in legislating in this way, that they'll seek to do the same. But if we are successful in opposing this bill, or if it's ultimately successfully challenged through the courts, if that's what's necessary, then it will also set that positive, you know, precedent also. But I just think it's deeply regrettable that this is where we are, and that, you know, 25 years on, victims are still being failed.
Just before we do a closing, I do a closing. I wonder if each one of you just want to say a word as we close out that you'd like to communicate to the audience.
Can I come in there? What has happened, and Gráinne has already touched on it. There was a partnership with the Irish government and the British government for the co-guarantors of the Good Friday Agreement. Sometimes it seems that the Irish government can be a silent partner, and for families like ourselves, we need a commitment. We need a verbal commitment, just like Nancy Pelosi has says about the Good Friday Agreement that dismantled. She had put a firm case that if this agreement is tampered with, there'll be no trade deal. You know that. So that's shown leadership. That's showing what would happen once you bring a certain thing, or once you do a certain act. So where we would be asking the Irish government to do the same, and the need to be coming out verbally and strongly. We will, on their behalf, we want them to say we will take a case once this is legislated, and we will bring the British government, our partners in the Good Friday Agreement, to the European courts. But just before I go, I'd like to thank, I say a lot of your audience, Irish Americans who we have met, who have been continually holding every Secretary of State till what goes over and tells their version of what happened in the North, with briefing from ourselves and other victims and other local politicians. You can keep the British government of their narrative of what happened or what they intend to do, but they can be held to account by the Irish Americans who support us and support us for many years. The AOHs, the LAOHs, the IAUC based in Washington. They've been to the forefront of campaigns and helping victims' families like ourselves in many, many ways. And I would just like to thank them and for them to continue the good work that they're doing.
Patty, Gráinne, closing remarks?
Yes, I just want to follow on from John. I mean, I do think the US administration have a crucial role to play in relation to this bill in the coming months. I do, like Gráinne, do understand our private conversations. I think that needs to go into the public. And some kind of statement from the US administration would be very, very helpful, particularly a critical statement from the US administration and to your audience who may be active in NGOs or the Irish American community or further afield. Any role or effort they can play would be gratefully accepted. And as John said, the US has been very good to families. They've listened at congressional hearings, at different events over the years that the families have travelled to. It's always been a very receptive audience. But any help at the minute would be critical and crucial in terms of how you might be influence your own administration to put pressure on the British government, who don't appear to listen to too many others, particularly the Irish government in my experience, but probably more likely the US administration. So keep doing the work, and where you can lobby and influence, this is the time to do it. We haven't got much time over the next number of months. And thanks again just for turning up to listen to us tonight.
Not got too much to add at the end of the conversation here, other than to obviously say thanks for the invitation to participate. And I think it's really important and timely that we're having this conversation, and for anyone there who can advocate and take forward some of the points that we have flagged and highlighted here this evening, I think that would be really welcome and obviously very important to do. So yes, thanks for the invitation.
Thanks very
Thank
much.
you so much to all three of you for your hard work in bringing justice and truth to light, and also for sharing a very late evening for all of you with us. I also want to mention to the audience, this is the fourth outstanding event we've had so far. And if you've missed any of the earlier three, if you just Google UMass GFA at 25, you'll be able to go to the website and see the recordings that are going up approximately a week or so after each event. Our final event will take place 2 weeks from today on Thursday, May 4th at 4 p.m. Eastern US time. And it's going to be held on the referendum on a united Ireland. So we look today at what was missing from the agreement, and the next event we'll take a look at the mechanism that is in the agreement that has not yet been exercised, and we'll have different views on the panel. So thank you again to our audience, and most importantly to our speakers.